Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez, tuning in from our San Diego office. Please join me in welcoming attorney Jacqueline Gonzalez Valle and executive manager team lead Carmen Lopez from our headquarters in Los Angeles. Hi there, Jacqueline and Carmen, and welcome.
Hello, hi everyone joining.
Hello, everyone. Thank you so much. Nice to be here.
Thank you so much for taking the time. For today's topic, we will be talking all about the H-1B do's and don'ts. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship, so if you do have questions, please email us anytime at info@chuk.com or comment them below. So let's get right into it. Jackie, can you tell me, when is an H-1B amendment required?
Sure. So an H-1B amendment is required when there's going to be a material change in the terms and conditions of the H-1B employee's employment. So one of the most common examples is a change in work location that is in an area that's outside of the original area of intended employment or a different MSA, a metropolitan statistical area. Other material changes include significant changes in job duties, job title, salary, reduction of hours. Let's say you're going from part-time to full-time or vice versa. All of those could require an amendment. The amendment must be filed before the material change goes into effect. So this means that, for example, if you're going to have an employee who's changing to a new project in a new city, that amendment needs to be filed before that employee starts working in that new location. An amendment is different from, let's say, a transfer or an extension. A transfer is usually a change of employer. So you're filing a petition as a new employer for a new employee that you're going to hire. And an extension is to request additional time on your H-1B status and I-94. But you can file a combined amendment and extension if there's going to be a material change and you want to request additional time on the H-1B employee status.
Okay, wow, great info. So I know you mentioned different MSAs. So would we need to file an amendment if the employee moves to a new work site in the same MSA? Carmen, can you give us a little bit of information on that?
Sure. Um, so if it's in the same MSA, you don't, if it's, for example, remote, let's say you live at home in Los Angeles, California, and you are going to be moving to Orange County, which is in the same MSA, or it's possibly a county, or even within maybe area of commutable distance, which is typically within 30 to 50 miles. Then you don't have to do an amendment. You just have to post the LCA for 10 days at the new work location, whichever that is. If it's your home, for example, we'll post it there. But a lot of times for companies that do a lot of consulting work, let's say, for example, IT companies where the work site is a client site, and they're moving to another client site, even if it's in the same MSA, we typically recommend, and I'll use the word recommend because there's not any clear guidance in any regulation that says that changing a customer site is within the same MSA requires an amendment, but it could be significantly different. Duties, for example, like Jackie described earlier, can consider to be a material change. So we do recommend that if it's a client site, even if it's in the same MSA, we do recommend changing, doing an amendment for that.
Wow, okay, something important to keep in mind then. What about the supporting documents? What documents should be included when we're filing an amendment? What does that look like?
Yeah, lots of times, clients come to us and think that an amendment is, something, not as detailed as an H-1B extension or transfer, but really all of those documents have to be submitted again. You have to submit the LCA, for example, the labor condition application. You have to submit a new I-129, and any documents that support the amendment. So, for example, if it was a change in level or responsibility of the job duties, you submit the duties. But that's all naturally part of the filing anyway. As I mentioned, it's the same as an extension, change of employer example. And you submit the pay stubs to show maintenance of status, W-2s, project details, statements of work. So for example, if you change from one client site to another, and it's a different client, you want to submit the client letters, vendor letters, consulting documents, things like that. So it's really everything that you would normally, file from any other ordinary filing. The only difference too would be the filing fees. Filing fees do differ when it's just a pure amendment and you're only asking for the time you already have on your current approval, or if it's an extension amendment, then you may be paying more filing fees, but that's what you would submit.
Okay, wow, really good to know. So what about short-term or temporary worksite changes? Do those require an amendment?
So that depends. It could potentially require an amendment. It depends on the length of time as well as other conditions. So there's something that's called the short-term placement rule, which allows you to place an employee at a new location for it can exceed 30 days, but sometimes you can get up to 60 days in limited cases. And then there are other requirements that must be met as well in order for an amendment to not be needed. So the regulations say that there can't be a strike or lockout in progress in the H-1B worker's occupation at that new short-term location. That's one of them. The second is that the employer cannot have an already certified LCA on file for that geographic area of employment. So if they have another H-1B employee that's had LCA for that location and they're no longer there, but that LCA is still valid, then you wouldn't be able to use the short-term placement rule. And then, as I mentioned, it cannot exceed 30 days, and that's consecutive and non-consecutive days within a 1-year period. But you can get up to 40, 50, up to 60 days. It can't be, exceed 60 days. If you can show that the foreign national is going to be maintaining their previous permanent, work site, work location, and that they're going to be completing the majority of that assignment and that work there. So for example, let's say you have an employee who is on a project in Los Angeles, California, and the employer, the petitioner, has that contract with end client A. So they're working on that project. And then the petitioner has another client, end client B, who is in need of a emergency project, right? And they need a IT software engineer consultant. In that case, the petitioner can temporarily place that employee with end client B for that emergency assignment in a different city, different location. And that wouldn't require an amendment because it's a temporary assignment, and the employee is going to be returning to their original remote work location in Los Angeles.
Wow, sounds like it can get quite complex here. So if you are watching this and have questions about any of this, feel free to reach out to us. We would love to guide you through this. So what about remote work or work from home arrangements? Do those require amendments? What is that about?
Remote work locations, yes. So again, as I mentioned earlier, people work from home, especially now these days. People work from home. If you're working remotely in the same MSA, you don't need to do an amendment, okay? But if you do move away from that county or MSA or within 50, like out of the 50 miles, then you will need to file an amendment if you work at a different location. And that's because of the wage, right? When you move outside of that MSA, the wage changes. So just because you move, even if everything else stays the same, let's say your job duty stays the same, SOC stays the same, you're still full time, you're still with the same end client even. But because you're moving from, let's say California to Texas, it requires an amendment. if it's remote, yes, absolutely. As mentioned earlier, you just have to post the LCA for 10 days before you move there.
Okay, some important things to keep in mind. So what about if the employee's job title or duties change? Does that require a filing or?
So if the change is significant enough that it's gonna really alter the job and the role and the responsibilities from the original petition, then an amendment would be required. So for example, let's say the employee is working as a software engineer in the original petition, but then you want them to work as a business analyst. That a business analyst is a different role, right? It has different responsibilities, and there's a different SOC code for that role. So that would require an amendment because that's going to change potentially the wage level, um, requirement. But minor updates to the job description, if it's still going to be primarily the same role and same SOC code and same wage level and responsibilities, then minor updates or additions to the job duties wouldn't require an amendment. So it just depends how significant the changes are to the role. Another common question that we get is, what about internal job title changes? The employee is going to be doing the same role, same responsibilities, but we're just changing the job title. Again, if that's not really going to change the SOC code or the level of responsibilities, then an amendment would likely not be necessary. But say, for example, you're going to be promoting someone, that would change their job title, and it might also change the level of their responsibilities. Maybe now they're going to manage a team or manage a department. That would change their job description and then increase their responsibilities and their wage level. So that would likely require an amendment. So it just depends on the level of change that's going to occur.
Got it. So you mentioned promotion. So what about like salary changes, maybe like somebody going from part-time to full-time? Would something like that trigger an amendment?
Mhm. So basically, it depends. It's always a depends, right? So if it's gonna be a cost of living or salary increment, and the duties primarily remain the same as Jackie had mentioned before, that would not require an amendment, okay? But what happens is that sometimes USCIS notices significant reductions and you're still doing the same job, for example, same SOC, and now you're getting paid significantly less or you're getting significantly more, then that triggers, attention to the officer. They feel like, is there a material change going on over here? Are the duties so significant that the responsibilities have changed, like, managing a team or having more responsibilities, like Jackie said earlier? So that would or may require an amendment, okay, in instances like that. As far as part-time to full-time, an H-1 can be part-time, it can be full-time. If you started as a full-time and now you want to go part-time, the LCA, the ETA 9035, does have a question, full-time or part-time. So you have to check that, right? So if it's full-time and now you want to be part-time, you have to file an amendment, for sure, 100%. Now, the question is that when you're going from like a part-time, you're already a part-time, and say you're going to be changing the hours. A lot of times clients come to us and say, I want to file a part-time H-1 for someone, and they want to put like a fixed number of hours. And I say to them, okay, if they're only going to work, for example, 20 hours a week, fine. If they're going to stay at 20 all the time, but if they're going to do 35 one week or 15, it's recommended to do a range, because then you get flexibility on staying within the range, okay? Like, let's say 15 to 35, if you work 15 one week, 20 the next, 35 the next, perfectly fine, because you're staying within the range. Now, there is no clear guidance that says that if you go from, let's say you put 20 hours on the I-129, because the I-129 is the one that actually asks for the hours. The LCA just says part-time or full-time. And the I-129 says part-time or full-time. If it's part-time, it asks you for hours. there's no guidance that says that if you go below the range or above the range, you're going to need an amendment. But, with this administration and, situations going on like this, it's always recommended that keep yourself flexible and put a range, That's what we recommend for part-time.
Thank you, Carmen. So what about a company name change or a corporate merger, for example? Would something like that require an amendment?
So in the case of, let's say, a merger, when there's a merger, that new company that has acquired the original H-1B employer, they're gonna be assuming all of the obligations of the H-1B employees, all of the H-1B employees that they've acquired. In that case, they don't, if that's going to be the only primary change, they don't need to file an amendment for all of the H-1B employees that they have. What they do need to do is that they need to add an attestation to their public access files for each H-1B employee with details of the merger and the assumptions of the responsibilities of the H-1B employer. But if along with the merger, there's going to be changes to the H-1B employees' roles or salaries or projects that they're going to be assigned to, then those are material changes that would require an amendment as a result of the merger. If there is a name change, but the company is going to be the same federal identification number, same company, it's just that their name changed. Again, that's not going to require an amendment since it's the same company. But if there's other material changes, then that is going to require an amendment. And then at the time that you file an amendment or any other H-1B petition, that's when you would submit details of the new company name or the new company that's acquired the H-1B employment.
So what if an amendment were to be required, but for some reason it didn't get filed, whether that's, maybe they just didn't know they had to, or, are there consequences for that?
Yes, we see that a lot, unfortunately. Employees move, they don't tell their employers they move because they're maybe doing consulting work. Definitely, there are violations. It means that if you didn't file an amendment and now you're filing it now, they will be looking at, information to trigger, to see if they fail to do it. So there would be potential violations to the employer. He would be in violation with USCIS and Department of Labor because he didn't file the amendment on time, okay? Because it is important that if there's any material change, like Jackie said earlier, you have to file the amendment first before you start working there. Unless you can take advantage of the short-term placement. Sometimes there's loopholes you could look and see if was it short-term, you didn't have an LCA certified and you can use those reasons. But definitely things that could happen too is that if you didn't file the amendment and you file it now and you're denied, you will be able to file another, you could file an amendment, but it may be consular process this time, right? So you'll have to leave the country for stamping because if they find that you didn't maintain your status, the case may be approved consular without the I-94 at the bottom, but you have to be aware of what was there any, findings of fraud or misrepresentation. Sometimes if the case gets denied for fraud or misrepresentation, even if you get consular approvals at the consulate, the fraud and misrepresentation can carry over to the employee depending on how significant it was. For example, we had a case where our client, the petitioner, filed 60 cases for a beneficiary, gave us the worksite of the end client, and submitted statements of work, and suddenly USCIS later on through a site visit verified it and saw that the end client was not a place. It was actually a house. It was an apartment actually. And so what ended up happening is all of those H-1 lottery cap cases that gotten approved got all revoked. Okay. And so you could try to do amendments before the revocation, but warning, it'll carry over, especially if it's a lottery. it'll carry over to the amendment eventually, because they'll say, well, you should have never even filed this to begin with, like the lottery case, for example. You're filing an amendment now for something that's carried over from a lottery that was fraudulent, that was never even a worksite at that location to start with, and the amendments, even if approved, can be revoked. And so that can happen. You can also do changes of status, before the revocation happens. For example, if your amendment is denied, but you could file it non-protunct, because if you did not maintain your previous petition, it will carry over to any change of status. They won't be approved, but you immediately lose your status, and if denied, if the USCIS finds out. And you can do the change of status non-protunct. Non-protunct means that you're asking USCIS to have sympathy, that there's going to be hardship suffered to the petitioner or even the beneficiary. There's some significant reason to not approve that change of status, even if they didn't maintain their status because they failed to file an amendment. So significant consequences. It's very, very important to always file amendments if needed, before you change whatever that change will be, that material change.
Definitely sounds crucial. So you mentioned that USCIS could deny the petition. So what happens if USCIS denies the H-1B amendment petition?
You're immediately out of status, and it starts to accrue from the date of the denial. So let's say that your case got just denied, no approval at all. You start accruing from the date of the denial. If you got approved consular, meaning that maybe they approved you, but on the merits, it required a bachelor's degree, there was a project for that amendment, but it got approved consular without the I-94. You got an I-797B approval instead. Then, you'll have to leave the country for stamping on that, and you will start accruing unlawful presence from the date of the denial. And you definitely don't want to go beyond 180 days, okay? 180 days consists of presence and employment. So don't go beyond 180 days from that date of denial. But now things are even getting tougher. We're getting notices to appear on people. You want to leave soon. Immediately, maybe within 10 days if you can. You have 30 days to appeal, but 10 days is probably the best thing. As soon as leave the country.
Really important information. Thank you so much, Carmen. Jackie, can you tell us what are some common issues that you see when our clients are filing amendments?
Yeah, one of the most common ones that we see, which Carmen touched on already, was that they don't file the amendment before the change actually occurs. So we'll see this a lot. We'll get a case for an amendment, and in the original petition, let's say the employee was supposed to be working in Los Angeles. And now for the amendment, they're supposed to be, working in Texas. But when we file an amendment, as Carmen mentioned, we're supposed to submit certain documentation, including pay stubs that show that they've been maintaining their status. But sometimes we'll get pay stubs that show that the employee hasn't been working in Los Angeles. They've been working in Texas already for, 6 months or so. And so that lets us know, they probably started the project ahead of time before filing the amendment. So that's very common. We see that a lot with the pay stubs, and that could lead to issues like Carmen mentioned, where they're going to be violating their H-1B status since the time that they started working at that new location, and that creates maintenance of status issues. So then at that point, they would be approved consular, or we could do a non-protunct request, but it creates, different issues that employers don't want to deal with. So it's always best to just file the amendment ahead of time, especially with the IT consulting, model of business, where they can anticipate when certain projects are going to end. It's important to keep track of those deadlines and try to file your amendments before the changes occur. Another one is the wage level on the LCA. When you're filing amendments and you're moving to different projects and different locations, the wage levels may change. And so sometimes the employer wants to stick to a specific wage level to keep the salary at a certain amount, but then USCIS will contact the end client and the end client will let them know, well, these are the actual requirements and it might require a higher wage level. And so if there's any discrepancy in that, then there could be an issue that would require an amendment. Again, usually with wage levels and amendments, that's where the wage level issue could come up, because when you're transferring them to a new city, maybe the wage ends up being higher. And so sometimes employers want to reduce or lower the wage level. So let's say they previously filed under level 3, but now that salary is going to be too high in the new location. So they want to go down to level 2. We don't recommend that just because it is based on the requirements of the position. So it is very possible that this new position may have less requirements, but you're going to have to justify why you're placing a very experienced person in a more lower level, entry level positions when you previously placed them in higher positions. So we recommend other solutions to try to figure out what can be done with the salary. Sometimes maybe you can keep them at a level 3, but then lower their hours or switch them to part-time, or maybe have them remain in their work location and work from home, but still change the project so that the wage can stay the same if they're working remotely from a certain area. So there are different solutions, but that does come up a lot with amendments. And then sometimes there's a lot of multiple amendments filed or pending at the same time. Understandably, with the IT consulting, projects can change and they may only last a couple months. And so you have to constantly file the amendments. But if there's a lot of amendments pending, it could create processing delays. One amendment may not be approved until the other one's approved. There may be confusion on, okay, what's the actual project they're working on now? And so it's best to try to avoid that. File premium if you can, so you can get your final decisions and not have a lot of cases pending at the same time, and try to consolidate or just, see foreseeable changes ahead of time so that you minimize the amount of amendments that are pending.
Wow, absolutely wonderful insights today. Thank you so much, ladies, for taking the time and answering all of these pressing questions and sharing these real life examples that you guys see on a daily basis. So that is all we have time for today. So this brings us to the end of our conversation. Thank you, everybody, for joining us today. A special thank you to you, Carmen and Jackie, for taking the time. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. Let us know what topic you want to see next. If you have any questions, email us at info@chubb.com, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again.
Thank you, everyone.
Thank you, everyone. Thank you, Arianna.
Thank you.